The employer has defenses if they are being charged with um, disability discrimination. Obviously, the employee has to make their prima facie case first and foremost. Once that is made, then the burden then removes to the employer for them to say that it is an LNDR. Um, and the employment action was taken for a reason other than the discrimination. Um, Lack of notice or employee cooperation is an iterative process. So if there was no notice or if there wasn't an agreement to engage in an iterative process, the employer can say, look, we tried to, we tried to make an accommodation. They didn't tell us in a timely enough fashion. And also, they were not cooperative in the negotiation. They simply said, this is what I want, and it's either this or nothing. And they gave us an ultimatum, and we can't do that. So again, their defense can be that the employee has not been cooperative in that process. Or they can say, look, no matter how hard we try, this is absolutely impossible and absolutely burdensome. It's not worth it for us to do this. So there are a number of things that they can talk about. They can say either there's another reason besides disability. They can say that, we tried, but the person wasn't cooperative, or we didn't have enough notice to be able to do that. Or lastly, they can say it's just not possible. It's just not feasible. For disparate impact cases, obviously it needs to be a facially neutral qualification that applies to everybody, and the business necessity defense has to be there. It's like, no, it doesn't matter if I can't do this. It is business necessity for us. It's job related for us to be able to do this. It is important, and it's really can't be changed. And so it basically they're arguing that no accommodation is possible or reasonable, that there's an undue hardship there, that it is consistent with what we need to do, and it is absolutely job related. So, and this can happen. I mean, certainly we can't say, well, somebody in a wheelchair could be a firefighter, and because it's just not possible for someone to fight a fire while they're in a wheelchair, to be able to go in to rescue people. It's an essential function of the job. So they can make the argument, right, that of course we're not going to have a high number of disabled individuals working for us who are in wheelchairs because we cannot make an accommodation that's reasonable for that. Now, I mean, obviously that's a very obvious and blatant an example, but there are other examples. I'm sure we will see, you've seen in the readings as well, regarding whether or not somebody could be accommodated by that. Mental or emotional impairments are also included, and we know that people with intellectual disabilities or impairments would be considered covered under the ADA. They define an intellectual impairment as an IQ below roughly 70 to 75. And that's about 6.5 million Americans who have an IQ that is below sort of the threshold that one would expect to be able to function adaptively and properly in society based on the way our society is set up, so that there are significant limitations in their ability to adapt in certain skill areas. And um, intellectual impairment means the disability originated before the age of 18, something that they had through their youth, and it's been a big part of their life. In terms of psychological impairments, the National Institutes for Mental Health says that approximately 1 in 5 adults, or basically between 46 and 47 million people, are given mental health services in a given year. Of these, 1 in 25, or 11 million, suffer very serious mental illness that interferes with or substantially interferes with one or more major life activities. These things include stuff like depression and bipolar disorder, anxiety disorders, PTSD, substance abuse, and psychotic disorders. These all fall under the definition of a disability under the ADA. And accommodations can be possible for this, but we have to figure out what that might be. For example, someone with depression may struggle getting out of bed in the morning, but they can then get moving by 10 o'clock in the morning. They may just need longer time in the morning to get up and moving, trying to accommodate medications and motivation issues and things like that. The courts are split as to what is considered a qualifying disability or accommodation. And so there is some tension with bullying and OSHA requirements in the context of workplace violence and how that it has an impact on emotional or mental impairments. In terms of harassment, there are currently no U.S. Supreme Court cases that address the issue of hostile working environment. Mostly it's the lower courts that have addressed this. There hasn't seemed to be much debate, which is why it hasn't gone up to the Supreme Court. And so the prima facie case for a hostile working environment is that the plaintiff is qualified with a disability protected by the ADA, that they were subject to unwelcome harassment, that it was based on their disability, that the harassment was sufficiently severe or pervasive to alter the privilege of their employment, any terms and conditions of therein. The employer knew or should have known of the harassment and didn't take prompt remedial action. Again, the organization cannot, in the moment, control harassment that's occurring if they're not made aware of it. But if they're made aware of it, and often the burden does fall on the plaintiff to let the employer know. But if now we know that the employer is made aware of a situation, and then given that, and they still choose to not do anything about it, then that's the prima facie case for disability harassment. With respect to things like workers' compensation, workers' comp is no fault liability for workplace injuries arising out of the course of employment, and it is very broadly, liberally interpreted on this. So if somebody is hurt while they are on the job, workers' comp comes into play. So that helps us in terms of accommodating someone who becomes disabled, whether temporary or permanently, while they're working on the job. So that some of the remedial history that you should be aware of, prior laws were hostile to injured workers. The purpose was to streamline relief for on-the-job injuries. So past history, long time ago, 100 years ago, probably, or close to it, we would punish workers, and we were hostile to them by saying, well, they're injured, out the door you go. So the employers will pay into a common government administered fund and based on the injury experience of the firm. Now, every firm has a different injury experience, right? An office that is mostly office and clerical workers has a very different industry injury threshold than a manufacturing environment might. So we want to be aware of the differences, right? The employee's benefits are certain if the workers' comp requirements are met, and they give up the right to sue the employer if they get the workers' comp. The employer gains freedom from lawsuits for workplace injuries because they consider it a no-fault situation, and it just gets paid, and we're done with it. There's a wide variation in the state-sponsored plans, but by and large, workers' comp is managed in a no-fault context and has to then be dealt with on a case-by-case basis. In terms of genetic testing, we've already spoken a little bit about genetic testing in previous lectures, but the investigation and evaluation of an individual's biological predispositions based on the presence of disease-associated genes is part of that. Now, the GINA, the U.S. Genetic Information Non-discrimination Act, prohibits employers with 15 or more employees from doing and requiring genetic testing and considering someone's genetic background and taking any kind of employment action. So the GINA sets the floor of minimum protection for genetic discrimination. It doesn't preempt state laws from having stricter provisions. So you can have a stricter provisions and you can say 0 employees, but at a minimum, that's the minimum, right? Is that we can have 15 or more, and we cannot use it to make high employment decisions based on that. So again, genetic testing is like it's the possibility that you might have a future disease. And if you recall, we said earlier in the lecture, right, that even if I have a genetic predisposition for something, the law states that that just because I might get the disease doesn't mean that I should be discriminated against because of that. So that's where this genetic testing sort of overlaps with that determination.